Hi, I'm Scott Sterrett with Sterrett Wealth Management. Today, very fortunate to have another edition of our interview series that we have from time to time with professionals in the Calgary and Alberta community. Today, I'd like to introduce Jonathan Ng. John practices with Underwood Gilholme estate lawyers. That's a group that works exclusively on estate matters. He's been judged by his peers as being one of the top lawyers, or best lawyers, pardon me, in Canada, working in trusts and estates since 2023. Really, his big role is assisting clients in preparation of wills, during power of attorneys, personal directives, trusts, advises executors and attorneys on, or pardon me, yeah, and attorneys on admin of estates. He's appeared in CBC radio across the country to discuss the importance of this area, and essentially that's what we're here to talk about today: is the importance of the area. But so John, before we start, so you're an engineer by trade. How the heck did you develop a passion for will and estate planning, being an engineer?
Yes. Well, the my exiting from my former profession is going to take a whole other episode, so we'll do that another day. But we'll fast forward to the time that I was fresh out of law school. I was working at a law firm that was practicing in an area that I was very excited about, cross-border litigation. I know your viewers are drooling at the mouth at how interesting that is, but I found it fascinating. And when you work as a junior, the seniors pile stuff on your desks, and the estate lawyer partner put an estate file on my desk. I was not planning on working on this area, and long story short, no turning back. I got into estates by accident. But what keeps me coming every day, admittedly, is educating people. I really like helping people understand what this is all about. It warms my heart to bring a confusing topic from the complex to the simple, and then ultimately empower someone with making their own decisions.
Great. Yeah. What are some of the must-haves that,
Mm.
because you've seen a lot, obviously, of again, throughout the years of files that are coming across your desk. And, you've seen a lot of situations that, people maybe not have been as diligent on the estate side, and you're being brought in afterwards to fix someone else's problem or to deal with an estate plan that hasn't really been planned. What in your view professionally are the must-haves that anybody, that's viewing this now, or anybody in general, should have?
Well, let's start with the trinity, the trio of estate documents that all Canadian adults should consider having. They are the will, enduring power of attorney, and personal directive. Now, note for any viewers that might be out of province, outside of Alberta, the latter two documents have different names. But I'll run through them real quickly, and you'll find that these three documents generally, although they might have different names, they are the same across the country. So the will is the centerpiece of the conversation. We're asking ourselves, if I die, who receives my wealth and who is in control, who is in charge of making that happen? And at the heart of it, that's the will. And in Alberta, the other two documents are known as the enduring power of attorney and personal directive. I use two different hands here because these two other documents operate while a person is still alive, in particular during a time when a person is mentally unable to make decisions on their own. So in those two documents, one is saying, I empower this person or this institution to manage my wealth while I'm incapable. And the personal directive empowers someone to make healthcare and personal decisions while during a period of incapacity. So death and incapacity at a high level are what estate planning is all about. And these three documents together form that trinity of documents that we traditionally prepare and continue to update during people's lives.
Okay. So, let's start with the will just for a second. And I guess power of attorney, well, all three really. I guess you could answer the same way in all of them. But when we look at these, as you said, an individual or corporation, you're assigning them the responsibility to do a certain task. How do you suggest people look for that individual? Because I mean that sounds like a pretty big job. One, it's a tough job, but two, it's a very important job, and you have to have a high degree of trust, I would think, with that individual or corporation. So maybe talk a little bit about how you would, kind of advise people to choose an executor or an attorney.
Sure. Well, I mean, it goes without saying. It starts with trust. This is going to be an individual, commonly an individual like a friend or a family member, um, uh, in whom you have trust in their financial wherewithal and financial literacy. If you're a business owner or own multiple properties, imagine this is someone who is now stepping into your shoes as an interim business owner or an interim landlord or interim property owner. So they should have similar traits and a similar skill set as you as they step into your shoes. Again, during a period of incapacity or in death. A common question or a common scenario I'm put in is when I'm helping parents with adult children. And the question is, which of my adult children do I choose? And a common motivator is to examine a person's day job. Like, for example, one might say, well, my daughter is a tax accountant here downtown. She's a partner at her international law firm. It's got to be her. And I would say a soft yes. She certainly brings great skills to the table, but we should look broader beyond someone's core skill set and day job. Sure, she is heavily trained and maybe overtrained in the work of being executor. She's got that covered. But let's ask ourselves, what does her personal time look like? Does she have the latitude in her life to do the 2-year job of being an executor or taking on the indefinite part-time job of being a power of attorney? Based on this individual's busy professional life, maybe she doesn't. Examine her family life and personal life. Does she have the latitude in her personal schedule to take on this role? Another consideration too is an individual's ability to get things done. Somebody's ability to wake up in the morning, write down a list, and at the end of the day, they've crossed everything off that list. I know that's mythical. We all aspire to be that person, but that I really mean that, and that's a key trait in being a power of attorney or executor. You have a list of tasks to complete, often in a concise period of time, and also often with a peanut gallery in the background. There are people with a vested interest in you getting your job done on behalf of somebody else. The jobs themselves aren't always complicated. Sale of a home, closure of a bank account, filing of taxes. These are tasks that individuals do sometimes, oftentimes, multiple times during their lives, but needing to do it in a short period of time with scrutinizing eyes around them. Now, that's a certain trait that goes beyond someone's day job. It goes beyond someone's training. Oftentimes, this is an intrinsic quality. And I'm hoping when I share this with individuals, with clients, this starts to light a fire as to who in their lives is the right person to get this done.
Great. Yeah. No, that's good. And do you find that, that people based on time and experience and things are suggesting, maybe one of my children or friends are going to be really good at the personal directive or the power of attorney, whereas somebody else might do the executor role? Or do you find that for the most part, the person who's the executor tends to be the person who's also the attorney?
Very much the latter. I think when we choose someone to wind up our estate on death, executor, and someone who would manage our wealth during our mental incapacity, they tend to be the same person. So attorney and or executor and attorney are commonly named to be the same person because it's a common skill set, it's a common ask, it's a common level of trust. But I do find putting those jobs on the side, this final role of medical decision maker, it's quite common that someone's considering someone completely different for this one, recognizing that it's a different ask, it's a different set of jobs. It is, and I want to dwell here for a moment. It's someone who has a sensitivity towards your views on healthcare, someone who has a sensitivity around your morals, someone who has a sense of advocacy, and this is the big one. Someone who's going to fight for you to make sure you're on the top of a wait list. Someone who's going to accept only the best from home care or only the best from our health providers. This advocate sometimes is also your power of attorney, but sometimes it's a completely different person.
Yeah. Okay. Yeah, and I've seen that a lot, and one of the other things I've seen a lot, unfortunately, is things that go sideways. And you've seen it, I've seen it, where you have some families that you think, oh, this is going to be easy. When mom or dad passes away, they all get along and things, and then you're like, oh my goodness, what just happened here? Like, whether it's because of money or something as simple as just a negligible value painting that the people just fight over. What do you see, or how do you counsel people with the pitfalls, of kind of the estate planning process, and what can you share as being, these are the things I've seen, don't do it, or these are the things that have worked really, really well. Please do this.
Yes. Well, let's start with the trinity of documents, right? That will, enduring power of attorney, and personal directive. I want to recognize that preparation of those documents certainly is the bedrock of estate planning, but that is absolutely, absolutely just the starting point. That is the starting point. Preparation of those documents, especially with a lawyer, is a private process, and it has to be. One must sit down with their lawyer and have a private and confidential conversation, and then come up with a plan that's has a legal and tax basis. That is only step one. And Scott, as you identified, there's certainly more to it to avoid the pitfalls. So building off of this bedrock of documents, this private process is now a process of communication. We open it. And what I'm going to identify are all shades of communication. So for example, in addition to these three documents that are sitting in a cabinet, let's bolster them with perhaps a binder or even just a sheet of paper listing where key assets can be located, the name of an investment advisor, the name of your insurance person. If you're the owner of a business, where is the minute book and the accounting completed? Helping that executor or attorney know where all your stuff is seems very intuitive, but is very commonly not done. And that's certainly something to consider. So communicating where assets and debts and business ownership are located. The communication continues. We were talking earlier about personal directive, healthcare decision making. Again, the personal directive is a document that enables the decision maker, but that's just step one. Conversations with that decision maker about your values, your expectations on healthcare are huge, because that agent, that decision maker under the personal directive might feel very powerless and again, under scrutiny about the care they choose for their mother, for example. So having conversations with your chosen people regarding healthcare expectations and documenting those conversations or documenting those wishes are helpful. Again, these are all examples of communication. Again, you start with these documents in a private process, so be it, but take it further with communication. You mentioned paintings. Oh my goodness. The distribution of personal effects is a huge area and sometimes a thorny area in estate administration. And helping your executor and beneficiaries with a letter. It doesn't have to be fancy. It doesn't have to be done by a lawyer. It doesn't have to be typewritten, witnessed, and notarized. It can be on a cocktail napkin, a listing of items that you feel should have special treatment and should go to certain people. Sometimes these are items of high value, but oftentimes they're items of simply personal value. But without your direction, without the will writer's instructions, the distribution of these items can be a very contentious area. So I want everyone to feel empowered, that they can take control and take that item off the table and create a destiny for that item. And heck, if family feels upset about who received it, they can go to the cemetery and yell at the deceased. Don't give the executor a hard time.
Right. Okay, got it. One of the things you've said, communication being a big part. I have a designation called Family Enterprise Advisor, and so it's a designation that helps with family business, things like that. And one of the tenets of that, what they call the three circle model, but one of the tenets of it is the communication part and having family meetings, not being so secretive about your estate plans or your legacy plans. How often do you see that actually happening? And is that, from a professional side, do you see that as a big benefit of, successful passings of assets from one generation to the other, or do you still find that being secretive sometimes is not a bad idea to avoid any fighting before the person has passed away?
Yes, I wish I had a silver bullet answer for you. And, I think I would certainly defer to the proposition that communication is positive, but communication is not always, especially full disclosure, is not always the answer, right? I have the privilege of working with families every day, and like many families, money was not something we talked about at the dinner table. It was just a bit taboo and just not appropriate, especially as they have young kids. Fast forward to children nearing middle age, parents as advanced seniors and needing higher level of care, and they still haven't talked about anything since childhood. And on one hand, yes, I preach communication, but I do want to recognize, are they going to suddenly have one pivotal Sunday supper with their 40 something children and suddenly say, all right, everyone, take a look. Here's our balance sheets. Here's the name of our insurance advisor. Let's talk about our death. I get that. That is awkward. But it is a slow transition if possible. Trying to impress upon our adult children what our expectations are and share with them where we bank and what our assets look like. It honestly should be a slow process, and it's a process that starts early on if we can. So for the families who have children that are 8 years old, no, maybe we're not passing around the balance sheet. But as our kids start to build wealth on their own, maybe in their 20s, perhaps as a litmus test, that's a place where we can start to share this information. That being said, families that didn't share this communication and didn't have the privilege of an open conversation dynamic, I oftentimes see success with those estate administrations. Just because there was silence doesn't mean there will be a lack of success. And oftentimes, I would observe that those families are going through the estate administration with success because of the relationship between the siblings. Sure, they may not have known everything about mom and dad, but their relationship as siblings, carries them through that estate administration. So this is, maybe a little bit another topic for another day, but fostering the relationships and being mindful of the relationships between siblings is what's going to carry them through.
Yeah. Yeah, that makes a lot of sense. Good. So last question before we wrap up. Obviously, just like there's a lot of investment advisors out there, investment professionals, and I have an answer on how you choose a good investment advisor. If someone were looking for, someone who, want to help with the estate planning, with the legacy planning, maybe some philanthropic stuff. We never talked about trusts today, but that sort of thing. How do you suggest that someone, or what types of questions someone asks before they choose a Jonathan out there to help them with their estate planning?
Yeah. Well, I think there's value in identifying, reflecting within first, right? And asking, what one should ask themselves, do I need the help of a specialist? Because it's important to recognize that there are many lawyers who prepare wills. And contrary to what some people are expecting me to say, I think probably the bulk of those lawyers can do a tremendous job. They really can. But I think the self-reflection that one must do first before looking into one is asking, do I have something a little more complicated? Do I have something in my life that might call for a lawyer who might be specialized in estate work? Because again, many lawyers do will preparation and estate administration work, but they might not be comfortable with a fact pattern that might be a little bit complicated. So, for example, the self-reflection might involve asking oneself, am I in a blended family? Am I in a blended family? Am I in a second or subsequent marriage or relationship? Do I have children from a previous relationship? Does my partner or spouse have children from a previous relationship? That injects a fact pattern that might be a little bit more complicated. So blended families, business ownership. So an individual who has an operating business, maybe there are employees, maybe there is property or leased space. That certainly attracts a lawyer that might have some experience or more advanced experience in estate work. Foreign assets. Now that sounds very very fancy. Foreign assets, like a villa in Italy. Sure, that would be lovely. But foreign assets can even be a cabin in Saskatchewan or a property in British Columbia, right? For listeners that are in Alberta. So something even out of province is considered foreign, recognizing that a state law is province to province. So a foreign asset could attract the need for a lawyer or professional that has more of a specialty in this area. And then finally, I suppose another self introspective exercise involves asking oneself, am I not distributing my estate to a certain family member? It's a heavy word, but am I disinheriting
Mhm.
somebody? Now, I
Yeah.
want people to know that that's not something to be ashamed of, and it's something that you're entitled to do. But in doing so, it does attract some legal complication potentially. And navigating that potentially difficult decision might be best with a lawyer who specializes in estates.
Great. Well, thank you very much. Those are really insightful, and I think gives people a pretty good idea on some of the options or some of the things they should look for before obviously contacting someone like yourself or, and going down their estate planning road. Um, if you do have any more questions for people listening, if you do have any more questions, please reach out to any one of us on the Start Wealth Management team. More than happy to suggest someone like Jonathan to help you in your lawyering estate planning needs. But again, thanks a lot, Jonathan, for allowing us to have this conversation, and hope you have a great rest of your day.
Thanks, Scott.